Next item, professional development and competence. Mr. Wardle.
Thank you, Treasurer.
Good luck.
So I'm pleased to present for information the report of the Professional Development and Competence Committee with respect to the evaluation of the Pathways pilot project and with respect to certain other enhancements to the licensing process. As you all know, the committee has been considering these issues since the fall of 2015. In April of 2016, the committee released a report that went to Convocation for information that dealt with a number of the proposed enhancements to the licensing process. Since that time, the committee has had actually a number of lengthy meetings over the past several months to consider the future of the Pathways project, which is now in its third year, as well as the licensing enhancements that were the subject of the April report. This report is the result of that effort. It represents a huge amount of work by the committee members over the summer, who very constructively and collaboratively reviewed drafts of this report over a very short time period, and also by the staff, particularly Sophia Spridakis of the Policy Secretariat, who used up her Labor Day weekend and I think a couple of other weekends helping us out. As I think many people here know, Sophia is finally retiring after threatening to do so for many years in December, and we owe her a debt of gratitude. So let me just deal first with the process before I outline the recommendations of the committee. The report has been made public and has been provided to all the Law Society's stakeholders and other interested groups. There is a written comment period that is open until October 19th. The committee is meeting in October, likely more than once, to review those comments. The report will then go to Convocation for decision on November the 9th. I'm now going to outline the recommendations of the committee. The formal motion is found on board books at page 32. So first, the committee recommends that the law practice program should end following completion of year 3. Second, the committee recommends that the enhancements to the articling program, which were introduced as part of the Pathways project, remain in place. Thirdly, the committee recommends that the Law Society explore a number of proactive steps to deal with ongoing issues relating to the transitional training requirement of licensing, including, first, exploring with the University of Ottawa and others potential ways to build on the groundwork laid by the Programme de Pratique du Droit, or the PPD. Secondly, considering ways that the English LPP resources may continue to be used by the Law Society, including adapting work placements to the articling context and integrating resources into the Coach and Advisor initiative. Thirdly, exploring approaches to bridging programs for internationally educated candidates. Next, exploring development of a fund which could be used to support the priorities of a diverse profession and enhancing access to justice in underserved communities within the transitional training context. Continuing to review issues of fairness, accessibility, and objectivity in connection with the articling program. And the motion contemplates that our committee will return to Convocation with a concrete plan with respect to these strategies by June of next year. Next, our fourth recommendation is that the Law Society approve a series of licensing process enhancements. And I'll just go through these quickly. That will continue to explore the development of a process to permit up to a 3-month abridgment of articling where prior skills training has been obtained in a program the Law Society accredits. That internationally trained candidates called to the bar in a common law jurisdiction with at least 3 years of practice experience be exempted from the articling requirement if certain criteria are met. that candidates continue to have 3 years to complete the licensing process and be eligible to write each examination up to 3 times, that the Law Society introduce a new practice and procedure examination to replace the current barrister and solicitor examinations, which must be taken prior to beginning experiential training, and a new practice skills examination to be taken after completion of experiential training. Now, the most significant of these recommendations deals with the Pathways project, and so I want to spend the balance of my time this morning discussing the rationale of the committee in making the recommendation to end the LPP. I want to point out first that this was not a unanimous recommendation. While there was a significant majority in favor of ending the LPP, there was a minority of benchers on the committee who felt strongly that it was too early for us to make this decision. So just by way of background, and I know everyone here is familiar with this, in November of 2012, Convocation approved a transitional training pilot program known as Pathways with 2 components, articling and the law practice program, to begin in 2014-2015. The pilot was for a period of 3 years to be extended for up to 2 additional years if the Law Society determined there was insufficient evidence to properly analyze the pilot after 3 years. A formal review of the program would be commenced in the 3rd year and would be completed by the end of that year. Convocation would then decide whether the pilot project should end, become permanent, or result in a different approach. And this approach and the formal motion that was approved by Convocation reflected concerns on the articling task force and at Convocation that the pilot project not become entrenched before an assessment took place. The articling task force defined the evaluation as including 3 things. First, the effectiveness of the alternative to articling as a means of transitional training. Second, the acceptance or otherwise of the alternative. And third, cost and equity issues. The Law Society retained research and evaluation consulting, known as RACON, with Dr. Ali as the senior evaluation consultant to develop the appropriate tools to capture the data. And Dr. Ali has now provided his report evaluating the first 2 years of the Pathways project, and that report, I should note, reflects the evaluation process that Convocation approved in February 2014. Dr. Ali's report is an appendix to the committee's report and is found at Board Books beginning at page 81. So let me turn now to the recommendations of the committee. The first determination for the committee was whether we can indeed evaluate the program and particularly the LPP at this point. The committee was unanimously of the view that both pathways, articling and the LPP, provide effective transitional training and that we do not require further information on either pathway to be able to evaluate those components of the pilot. The tougher questions really revolve around fairness and sustainability. The prevailing view, that of the majority of the committee, was that we have enough information now and that allowing the pilot to run for another 2 years will not make a meaningful difference. And you'll see that view expressed at paragraph 47 of the report. The majority's conclusion is that the concerns that have emerged about fairness and sustainability are not likely to diminish if we give the LPP another 2 years to run. However, I do want to make it clear that that was not the view of all committee members. A minority thought that we should give the project more time and consider and possibly put in place alternatives before ending the project. So the second decision for the committee was whether to recommend a convocation that the Pathways project, and particularly the LPP, be continued, end, or lead to a different approach. The issues discussed by the committee regarding this decision are as follows. First, there appears to be no doubt that the LPP has provided effective skills training for the candidates who have taken the course. and the providers have done excellent work in creating programs that have met our requirements and indeed in some ways have surpassed them. Second, the LPP has proven a vehicle to become licensed for candidates who otherwise were unlikely to be. So it has filled part of the shortage of positions which were the concern to begin with. About 230 positions a year. However, the LPP has also given rise to three concerns. The first is one of fairness. In the view of the committee, there is convincing evidence that the alternative pathway of the LPP is perceived as a second-tier process primarily by the candidates themselves. I emphasize the word perception because there is no evidence to suggest that the LPP-PPD is in fact second tier or merits that perception. However, from Dr. Ali's work, including surveys, entrance surveys, exit surveys, focus groups with candidates taking the course, many of the candidates appear to consider it a second best solution. And I'm just going to highlight some of the data. First, a declining percentage, 27% in year 2 versus 38% in year 1, are reporting that it was their first choice for experiential training. Candidates switch out of the LPP if they can find an articling position. Some candidates are expressing concerns about whether they are stigmatized by having gone through the course. Candidates have not taken up the LPP in numbers as great as expected. Our estimates were for approximately 400 candidates a year. It's well below that at around 230 overall. There are a significant group of candidates from the current and prior licensing cohorts, over 200 students, who do not have articling placements but are nonetheless not pursuing the LPP. Candidates are not being hired or hired back out of the LPP at the same rate of articling, and more of them appear to be going into sole practice. And finally, many candidates have complained about financial affordability of the LPP in comparison to articling, because the students are unpaid during their course component and because some work placements remain unpaid. And I just want to emphasize here that this is the information that's been gathered by the consultant the Law Society retained as part of our approved evaluation process. So it's not coming from the committee, it's coming from an independent source. So the question for Convocation, and I'm going to pose it as a question at this point, we have to determine, are we creating a fair and defensible alternative for these candidates, or are we simply creating a second-tier process which has the potential to unfairly stigmatize them? Or to put it a little more simply, do we want to entrench a licensing system where one pathway is not accepted by candidates as equivalent to the other? Now that's the first concern. The second concern is sustainability. You'll recall that Pathways is being funded in two ways. First, a $1 million annual contribution from the profession, and second, an increase in the licensing fee for all candidates of $1,900. Effectively, the entire licensing cohort is subsidizing a percentage, approximately 10%, through a licensing fee increase of $1,900. It would be difficult to justify continuing this subsidy if the LPP becomes permanent. It simply wouldn't be fair to those taking articling who have financial burdens of their own. However, given our current numbers, if the subsidy were removed, the unsubsidized cost per candidate of the LPP overall could be as high as $17,000, and the cost for the Ottawa PPD would be significantly higher. And that, I just want to pause and say, is a direct result of our numbers problem. We wouldn't have this problem if more candidates were choosing the LPP. The third concern is the performance of LPP candidates in our licensing process. The failure rate for the first attempt at the barrister and solicitor examinations is about 16.1% for articling candidates and 43% for LPP candidates. We also have a group of LPP candidates, approximately 20% from year one, or 45 candidates who still have not completed our licensing examinations. So these are candidates who are being subsidized by their cohort and by the profession for the cost of the licensing process who are simply not making it through the process. The statistics from our licensing process also raise concerns about the readiness of a number of internationally trained candidates entering our licensing process through the NCA. 47% of those candidates are failing their first attempt at our licensing examinations. And that also raises concerns with respect to the LPP because approximately 50% of the candidates taking the LPP are internationally trained, both returning Canadians and true international candidates. Now, I want to make it clear that the performance of LPP candidates on our licensing examinations has nothing to do with the LPP providers. They are putting on a skills-based course, and they're not focused on helping candidates pass our licensing exams. However, it does raise questions about whether we are devoting a significant effort in terms of intellectual capital and funding to a relatively small percentage of candidates in the pool, some of whom are simply not ready for one reason or another to be licensed. Those are the three reasons that influenced the majority of the committee in making the recommendation to end the LPP. However, as I said earlier, the vote was not unanimous. A small group of benchers believing that it is simply too early to make a final decision. Now, we've set out in the report a number of strategies the committee believes need to be explored in conjunction with the termination of the LPP. I'm not going to elaborate on them today, but they are set out in the motion at paragraph 3, and they're described in detail in the report. I do want to emphasize that the committee recommends that we continue to scrutinize issues of fairness, accessibility, and objectivity in connection with articling, particularly around the hiring process. That's the summary regarding the committee's recommendations in regard to the law practice program. The committee was also of the view that the articling enhancements created as part of the Pathways project should continue, and we have made a number of recommendations to enhance the licensing process, all in conjunction with the Law Society's strategic priority to focus on enhancing licensing standards and requirements. So all of these recommendations will come to Convocation in November for a debate and a vote. I wanted to make one final comment on the motion. Certain of the recommendations are independent of each other, so this is not a take it or leave it. In particular, the committee is recommending that the proposed enhancements to the licensing process be considered independent of Convocation's decision with respect to the LPP. So you can see that in the breakdown of the motion that's on board books. And so the view at the moment, and that's subject obviously to further discussion, is that all of these items would be voted on separately rather than as one package, take it or leave it. So that's the report.
Thank you very much, Mr. Wardle. So, as Mr. Wardle said, this is a matter for information today, and I know for many of you it's a bit of a repeat of an information session, but it's important, I felt, to have this stated publicly in Convocation. We will have a full debate on this in November. If there are any questions relating to the procedure, the process we're following, or if there are questions in the nature of clarifications that people need, this is an opportunity for that. But otherwise, of course, there will be plenty of time to deal with this issue in November. So any questions in that regard? Mr. Evans.
Thanks, Treasurer. Mr. Wardle, I've read this with interest and wondering about it. My question is, We bought this LPP program about 3 years ago because of a crisis in the profession. And my concern is that if we discontinue it, the crisis will return and we won't have a way of coping with it. I'm wondering if that is considered by the committee and what your anticipation is.
So I think I'll make a very fast answer, and that is just that that clearly is one of the considerations the committee wrestled with. You'll see, though, from the numbers that, in fact, because of the growth of candidates coming internationally through the NCA process, we actually have a gap right now, even with the LPP. And that gap is just not, it's just not possible for us to get rid of that gap, just because the number of internationally trained candidates is now about 600 a year. And that's a combination of a number of factors, including increased enrollment at Canadian law schools, students who are going abroad to study in increasing numbers, and an increased number of candidates coming to our province who are truly international in origin. So it's a complicated set of factors, but right now we have a shortfall even with the law practice program.
Mr. Faulkner?
Treasurer, through you to Mr. Wardle, first of all, obviously my congratulations to the committee for the extraordinarily tireless work. And while many of us were on cottage docks or the like, these folks put in long hours in trying to at least structure the debate that has to happen. I don't, and I'm not up to sort of engage in the debate at this stage, but I raised a process issue that I asked Mr. Wardle and the leadership to consider over the months to come in terms of trying to assist us with feedback. As I see it, there is somewhat of a disconnect between what Mr. Wardle has laid out and the committee's laid out in its report and the expectations some of us had of this program at this stage. And by that I mean that the expectations I had in supporting this program were not that it was not going to be seen as a second best. I assumed it would be seen early as a second best. I assumed that the program would struggle in early days because there is not a single fledgling program that does not. I need to have a better understanding as we progress along this. What were our expectations in early days? I assumed we'd hit bumps in the road. That didn't tell me that I'd want to throw out the baby with the bathwater. And the reason I raised this is that I supported this because I felt it was a way to ensure people were licensed that were otherwise not getting an opportunity to be licensed. That was my expectation. I need to see and have an analysis that helps me on whether those expectations can be met and the program kept, or whether we are dealing with another set of expectations and therefore identifying the program as a failure. So it would be of assistance to me as we go along in this process to properly identify the expectations we had going in. Because I worry that at the end of the day, as we discard this program, I am faced with the same problem all over again, which is people not getting licensed that should be licensed. So I appreciate if that can be included in the process. What were our expectations? Thank you, Treasurer.
Thank you, Mr. Faulkner. Duly noted. Any other questions? Yes, Ms. Pulitzer?
I've asked this question in the context of being the chair of the committee at the Federation that approves new law programs. And we know that there are new law programs that are going to be applying for approval as early as the end of this year. So including law programs in Ontario. So, and the numbers we anticipate, at least for the Ontario program, to be significant. Given that there are likely to be new programs coming in that are going to expand the number of demands for article in places, can perhaps we consider, you can advise whether or not there's been a consideration of the new law programs that are going to be starting or appear to be coming down the pipe.
So I thank Ms. Blitzer for that. I don't think there's been an explicit discussion around that point as yet at the committee, but I will certainly bring it to the committee's attention and we'll put it on the agenda for our next meeting.
Thank you. Any other questions or remarks in the room at this stage? Yes, Mr.
Thank you, Treasurer. Through the Treasurer, I had an opportunity to speak to Mr. Wardle yesterday, and one of the items that I had concern with is our definition of fairness. I take the view that fairness has to do with us as a society ensuring that the public is protected by having exceptional candidates who become licensees. The program itself, when you look at the report, shows that it is an excellent program, and it is a success. So what I'm hoping, and I've had an opportunity to speak to Mr. Wardle, is that when they look at the different permutations and options available, that we think about running this as a universal program, maybe reducing it to 3 months and allowing it to run more than once a year. And that might be 2 times a year, 3 times a year, 4 times a year. That way we will be able to ensure that all candidates get the proper amount or proper learnings, and it's just something that I hope the committee could consider.
Thank you, Mr. Cooper.
So I think I'll just indicate, I talked to Mr. Cooper, but a lot of people in this room have interest in this topic. I'm pleased to take whatever suggestions people have and reflect them back to the committee. Just everyone should bear in mind that this is a very complex process. We've been struggling with it for a long time. I think the tenor of the report was to say, if we decide to terminate the law practice program, it doesn't mean that we're just going to go back to the status quo and pretend that it never happened. And there are other things we need to be doing short-term as well as long-term. I think that's as much as I can say for now.
All right. Given the limited nature of the questions, I should just see whether there's anybody on the telephone who has any question or comment in the same limited
is no longer
vein.
in lecture mode.
Are there any questions on the phone?
No, thank you.
No, thank you.
All right. Very good. Thank you very much, Mr. Wardle, for that. And I too want to
The
echo.
conference is in lecture mode.
I too want to echo the comments you and others have made about the hard work of the committee and in particular of Ms. Spardakos, who I know I bumped into at the end of the Labor Day weekend and commented on how quiet the building could be over that weekend. So thank you, Sophia, for that.